Hello everyone, we've been making the RPC videos for the mobile phone format, 3 minutes or less for each rule, and the ultimate goal is to reach rule 54. We want to try something new though. We want to make a compilation video for these rules reformatted to a bigger screen. Doing this will allow us to optimize the videos properly by grouping them into chapters for easy referencing. We'll have a total of 6 compilation videos by the time we're done. These 6 videos will represent the 6 parts of chapter 1 of the RPC. So just in case the vertical format isn't doing it for you, this is going to have a standard horizontal format. This particular compilation video will focus on part 1, practice as a legal practitioner. And with that out of the way, enjoy the video. Rule 1. General responsibility of a lawyer. So this rule is an easy one. Some people call it the omnibus rule, others call it the rule you put in your answer booklet to a question relating to the RPC. I mean, if you don't know the specific rule that applies, just use rule 1, am I right? No, please don't do it. Learn the specific rules. So what's the gist with this rule anyway? Well, it just highlights the general responsibilities of a lawyer, like upholding and preserving the rule of law, promoting and fostering the course of justice, maintaining a high standard of professional conduct, and not engaging in any conduct which is unbecoming of a legal practitioner. Straightforward stuff. An important note about that last point, as you'll come to know later, there are generally 4 offenses for which a legal practitioner can be disciplined. Out of those 4, we have the infamous conduct in a professional respect, and conduct which, though not amounting to infamous conduct, is incompatible with the status of a legal practitioner. So the former one relates to professional misconduct, basically rule 2 and all the other rules that come after. So for example, misappropriation of your client's property is an example of such professional misconduct. Now the latter is what's being referred to in that last point. So conducts like habitual drunkenness in public places, using foul language in public places, fighting in public places, seducing your client's wife in public places, not just in public places, anywhere actually, are considered conduct which, though not amounting to infamous conduct in a professional respect, are incompatible with the status of a legal practitioner. And with that, you now know Rule 1. Rule 2. Duty as to admission into the legal profession. Now we're going to look at Rule 2, which is a duty as to admission into the legal profession. This is basically saying that a lawyer should not knowingly do something or make an omission or engage in any conduct that would lead to the admission of a person who has certain commas. If we look at it closely, we can see 3 highlights of the persons who are unsuitable to be admitted into the profession. The first is a person of questionable moral character. So if you're a law school lecturer, for example, and you observe that a student is already capable of dirty politics at the SRC level, you have to make sure that such a student is not admitted into the profession. The second group of persons are persons with insufficient qualification. So as a lawyer, if you know that a student has insufficient qualifications and you turn a blind eye towards such a student, and the student gets admitted into the legal profession, you've indirectly helped him obtain enrollment by fraud. And that's unethical. The right thing to do is that you have to report him to the proper tribunal. The third category is persons unsuited for any other reason. Now this one's very vague, and honestly it could mean anything, from something as serious as disrespecting a lecturer to minor infractions that you might think won't mean much. If a person isn't fit and proper, he shouldn't be called to the bar, irrespective of whether or not he's a brilliant student. Now if by some miracle they find their way into the profession, if you as a lawyer should notice a fellow lawyer with corrupt or dishonest traits, or a lawyer who has obtained enrollment by fraud, then you have to report him to the proper tribunal. Removing these lawyers with corrupt or dishonest traits would help to protect the dignity of the legal profession. And if you're able to report these lawyers who obtained enrollment by fraud, this would greatly improve the quality of legal services, as those services would be rendered by qualified lawyers. Rule 2 is basically just telling us to snitch. If you see these unsuitable persons, just snitch. And with that out of the way, congratulations, you now know Rule 2 of the RPC. Rule 3. Aiding the unauthorized practice of the law. What's it about anyway? It's simply about you as a lawyer not aiding the unauthorized practice of the law, either by a non-lawyer or someone who has been disqualified from the bar. So this means that if your name is not on the roll of legal practitioners, then you have no business practicing. To illustrate this point, I'd like a little side note. Have you watched the series Suits? Not Suits LA, I'm talking about OG Suits. If you haven't watched it yet, I highly recommend. Anyways, just a quick recap. In the series, there's a character called Mike Ross. He's a smart guy with a photographic memory and a great asset to any law firm. There's just one problem. He's a college dropout who didn't go to law school, meaning he's not authorized to practice law. This is his boss, Harvey Specter. He found out about Mike Ross's secret, but because Mike Ross is that good, he aids him by keeping his secret. Rule 3 frowns upon this. So according to Rule 3, a lawyer should not aid unauthorized practice of the law. Also, a lawyer can't allow a non-lawyer to do stuff in his name. And a non-lawyer also can't use a lawyer's name, seal, letterhead, anything that gives an impression that the lawyer did the work, when it was actually the non-lawyer who did it. Another thing that Rule 3 suggests is that the lawyer can't share his legal fees with a non-lawyer, except as provided in Rule 53, which we'll get to later in the series. I just want to emphasize on this point that this also applies to persons who have been disqualified from practicing, not just non-lawyers. In conclusion, don't help unauthorized people practice law. If you feel the work is too overwhelming and you don't want to do it yourself, just pay another lawyer to do it for you. Rule 4. Avoidance of intermediary in the practice of the law. So this rule is pretty straightforward. It's simply avoiding a middleman in your law practice. Simply put, don't allow a middleman person or company that's a lay agency control you, exploit your services, and dictate how you relate with your clients. If it's not a law firm controlling your services or giving you briefs, it's unethical. Honestly, I think this is one of those instances where the RPC is saving your life by threatening to punish you. Because think about it, if the lay agency forces you to do something and it affects your client negatively, the client will take action, and guess who will be in trouble? You, not the intermediary that exploited you, but you. Another point to note is that if the intermediary interferes in your practice, you're likely to share your legal fees with him, which is also unethical. An exception to the whole intermediary saga is charitable societies rendering help to indigent persons. This makes sense because these organizations are paying the legal fees for the indigent people, as these people can't afford them, basically providing them free legal aid. And these organizations are non-profit, so unlike lay agencies that want to exploit you for money, they don't compromise a lawyer's professional independence, as their goal is not to control you, but rather to help the indigent persons. Indigent is basically another name for poor and needy. Rule 5. Association for legal practice. Now we're talking about Rule 5, which is about association for legal practice. One important but often overlooked fact of life is that in order to make money, you must collaborate. This rule just guides how you associate with people as a legal practitioner. Now, what are the highlights of this rule? One highlight is that you can actually partner with a non-lawyer, but make sure the activities of the partnership are not related to law practice. For example, your partner can handle the buying and selling portion of the business, and you as the lawyer will handle all the legal stuff. Another highlight is that if there are 2 or more law partners in a firm, and one of them dies or leaves the partnership, the name of that partner can still be used as the name of the partnership, as long as you're not using it to deceive people. According to Sub-Rule 3, another highlight is that when one partner gets elevated to the status of a judge, his name has to be removed from the partnership name. That upgrade from the bar to the bench means that his name can't be associated with the bar. Another highlight is that if you are practicing alone, don't lie to potential clients that you're a partner in a firm of lawyers. It's unethical to fake it till you make it in this instance, and it's better to be honest and upfront with your clients. Sub-Rule 5 also states that you cannot carry out legal practice as a corporation, that is, a company. Just in case you didn't know, a law firm is not a company, it's a partnership, hence the phrase, I made partner. Rule 6. Retirement from judicial position or public employment. Now we're going to talk about Rule 6, which focuses on retirement from judicial positions or public employment. I'll dissect it into parts for critical understanding. If you're a judicial officer in a superior court of record, then you can't be an advocate after you retire. The Nigerian law school churns out at least 2,000 barristers every year. How are they going to compete with a retired honorable justice who has years of experience under his belt? They already have a difficult time competing with the legions of senior advocates of Nigeria. It's just going to be overkill at that point. There is an exception to this part of the rule, however. The retired judicial officer can defend himself in court, and in that instance, the court will grant him audience. Another highlight is that retired judicial officers can't sign pleadings for the purposes of any proceedings. This makes a lot of sense because the signature of a retired honorable justice holds a lot of power and influence, which would make us question if the presiding judicial officer has been compromised or not. While judicial officers can't appear in court for another person, they can practice as solicitors or legal consultants. This is because they have vast experience in law, and it would be a waste to just let all of that vanish after retirement. The legal consultancy could be on matters that he may have adjudicated on, or on fresh matters. It goes without saying that it's impossible for a judicial officer to be an advocate at the same time during his tenure. He can't even be a solicitor in that instance. This is because a judge is to be seen as an impartial umpire, and a judge advocating and soliciting could fetter his discretion. Also, A retired judicial officer may continue to use the word justice as part of his name. It's an honor. It's important to state that magistrates aren't judicial officers, so this rule doesn't affect them. Now that we are done with the first category, let's head into the next one: retirement from public employment. Now, what about lawyers in public employment? Can they practice after retirement? Can they act as solicitors? The RPC states that they can neither practice nor become solicitors over matters they've dealt with as legal practitioners while in office. The rule also contemplates a situation where a public officer may have been appointed in judicial capacity to oversee tribunal proceedings. He also won't be able to practice or be a solicitor for such matters that he adjudicated upon. Now, there's a question that hasn't been answered yet. What if the judicial officer didn't retire but was dismissed from office? Would he still be able to practice? Well, Section 292 of the 1999 Constitution helps with that. Looking at the provisions, it says that after such a dismissal, he cannot appear as a legal practitioner before any court or tribunal. This means that he cannot also sign pleadings of any proceedings as well. Now, there can be an instance where the judicial officer wasn't dismissed but voluntarily resigned from office. Can he still practice? We can reference Section 292 sub 2 of the Constitution again, paying close attention to the phrase ceasing to be a judicial officer for any reason whatsoever. This means that if you resign voluntarily, you'll be on the same boat as the judicial officer that resigned at the age of retirement, and you'll be barred from advocating for the same reasons. Rule 7. Engagement in business. We're about to cover the most popular rule in the legal profession: engagement in business. Unless the General Counsel of the Bar permits you, the general rule is that you can't engage in business while practicing law in Nigeria. Let's look at what you can't personally engage in while practicing. Any business of buying and selling commodities is not allowed if you have to do it personally, because you have to be actively present in the shop and it will conflict with your lawyer job. Secondly, any business where you personally have to be a commission agent will be a distraction to your law practice, which may be detrimental to your clients in the long run. Thirdly, other trades or businesses that the Bar Council may from time to time declare incompatible with the legal profession. For example, being an active pepper grinder or OnlyFans. Strangely enough, the Bar Council permits lawyers to engage in farming while practicing law. Maybe growing your own food is seen as noble and that's why it's permitted. I don't know. If you have an idea of why the Bar Council permitted this, feel free to drop a comment about it. Now, there has been this misconception that the RPC doesn't want you to have a business while being a lawyer, but that's not necessarily the case. The Bar Council just wants you to not personally engage in the business. Speaking of trade and business, the RPC actually permits some form of participation in businesses, as long as they have minimum interference with your lawyer work. These include being a non-executive member of the board of directors of the company. So basically, a non-executive director doesn't see to the day-to-day activities of the company. He just attends meetings once in a while. Another is being a secretary of a company, i.e. a company secretary. This role doesn't interfere with your lawyer work, and one can argue that it gives the lawyer more experience in company law. Another is being a shareholder of a company. This usually just involves attending general meetings as you own equity in the company, so you're not doing any actual work. Now that we've looked at this rule, what do you think about it now? Are you of the position that the rule should be revised to reflect the modern day realities of a young lawyer? Or are you okay with the rule as is, as it shows that you can have a business alongside your law practice if it doesn't involve your full engagement in it? I'd like to know your thoughts in the comments. Rule 8. Lawyers in salaried employment. Now we're looking at Rule 8, which talks about lawyers in salaried employment. Now, this rule is one of the first rules that leaves you scratching your head. Why is there a prohibition on legal practitioners in salaried employment in the first place? Why can't they appear in court? Let's look at the highlights of this rule. A lawyer in salaried employment cannot appear in a court or tribunal on behalf of his employer. You may ask, then why are we giving him money? That's why I'm here, to explain this madness. Firstly, the RPC only states that he can't appear in court on behalf of his employer. It doesn't state that he can't appear for anyone else. Secondly, the RPC didn't state that the lawyer couldn't be a legal consultant or a solicitor for his employer. It just focuses on the advocacy part and other things related to advocacy. This means that he can't prepare, sign, frank documents and instruments that may eventually relate to court proceedings, unless the rules provide otherwise. Another point is that a director of a company can't appear in court on behalf of the company as an advocate. The fact that he's a non-executive director is irrelevant. But remember, nothing stops him from being a solicitor or legal consultant. He just can't advocate. Also, a lawyer in full-time salaried employment may represent his employer as an officer or agent in some instances. But the lawyer won't wear his robe. Let me illustrate this. Imagine that there's a case between some random person and the Federal Mortgage Bank of Nigeria, And then we have James, a non-executive director of the bank, who also happens to be a legal practitioner. Now, on behalf of the Federal Mortgage Bank of Nigeria, James comes to court with his legal team, as he's a natural person, but the bank, being a legal personality, would still need an agent apart from the legal team to represent the bank. This means that if James wants to be in the proceedings, he cannot be rogued. This signifies to the courts that he's not coming as a legal practitioner, but as an agent of the bank. Another point to take note of is that a legal practitioner who is also an officer can be a judge advocate in a court-martial. So in that case, he's appearing before a court-martial because he's appointed and constitutes the court-martial, not necessarily because he wants to be there. It's important to note that in this case, he's discharging his duties in the capacity of a military officer, not a legal practitioner. So I've just told you that lawyers who are in full-time salaried employment can't appear in court for their employers, but I didn't tell you why. The reason is because the legal profession has a lot of lawyers who need work, and if the employers are allowed to utilize their in-house lawyers for everything, that is, advocacy and legal consultancy, there would be a shortage of work which could ruin the lawyer work economy. It also has the potential of shortchanging the lawyer in salaried employment, as his remuneration is no longer seen as general or special retainers, but is tied to his salary that covers all legal work, which may not be fair compensation. This is against Rule 49 in RPC that talks about retainers, and we'll get to that later in the series. Rule 9. Practicing fees. Rule 9 talks about practicing fees. The most important thing to note in this rule is the date you are to pay the annual practicing fee. If you get called to the bar and you enroll at the Supreme Court, you have within 1 month after enrollment to pay your practicing fee for the year. Then afterwards, you must pay your annual practicing fee not later than 31st of March in every year. If you don't pay your fee, you'll be denied the right of audience in court. If you lie about paying it and they catch you, that could be seen as a contemptuous act and you'll be in trouble. Also, it goes without saying that if you don't pay your fees, you can't sign documents like pleadings and affidavits. You can't also file processes. Think of it this way. If you, as the lawyer, are a smartphone, and your law practice and expertise is the battery, then that means the practicing fee would be the charger. If you don't charge the battery of your phone when it gets flat, you can't use it for calls. Same with the law profession. If you don't pay your practicing fees, you won't be able to practice in court. Now, what are these fees? The fees vary from time to time, so these figures are tentative. But from what I've noticed, the price doesn't change that much. As at 2025, the senior advocates and body of benchers will pay $50,000 in a year. Lawyers 15 years and above post-call pay $25,000. Lawyers 10 years to 14 years post-call pay $17,500. Lawyers 5 years to 9 years post-call pay $10,000. And lawyers below 5 years post-call pay 5,000 naira. So now we've seen that the practicing fees are compulsory to pay and they are being gathered somewhere. But where does the money go? From what I can gather, it seems like the payment is made to the NBA portal. And from there, 10% of the yearly fees gathered goes to the body of benchers. The NBA retains the remaining 90%. Now let's do some quick math. So the average number of lawyers we have in Nigeria are about 250,000. The minimum payable is 5,000. That would give us 1.25 billion naira on average. 10% of that is 125 million naira per year. And that's the minimum. That's a lot of money from just 10%. I don't even want to be thinking about how much the remaining 90% will be. Now, what is the money used for? NBA uses it to make the lawyer atmosphere better. As a law student and a baby lawyer, you may not understand. And honestly, some adult lawyers don't understand as well. But it's for a good cause. But what about the 10% that goes to the body of benchers? I don't know. Tight, I guess. In conclusion, in the law school, it's possible to see questions that test you on this rule. So I want you to open your eyes and ears one more time. When you are called to the bar, you have within 1 month afterwards to pay your practicing fee. Then subsequently, you pay every 31st day of March. For everyone else, pay 31st of March. If you've been called to the Nigerian bar, you can't do anything until you've paid your fees, so make sure you pay them. Rule 10. Seal and stamp. Today we are going to be talking about seals. No, not that seal. Not this one either. There we go. This right here is the NBA seal, and it's pretty important for any process you wish to file in court. It has the lawyer's name, obviously, then the enrollment number, then this cool serial number that has a degree so you know it went to school just like you. It also has an NBA logo and an expiration date. Let's look at the highlights of this rule and what it has to say about seals and stamps. So firstly, if you're a lawyer and you are acting in your capacity as a legal practitioner, your documents and processes must have a seal and stamp approved by the NBA, then a signature to accompany it. I want you to take note of the word acting in capacity as a legal practitioner. This means that not every letter you write must have a seal and stamp. For example, if you're writing a love letter to your girlfriend, it makes no sense to put a seal and stamp there unless you want to flex. However, if you plan on serving a writ of summons on your girlfriend, then you have to frank it with a seal and stamp. Why is it compulsory? Believe it or not, the seal and stamp policy is a fairly new policy, started by the NBA to help curb quack lawyers that were not called to the Nigerian bar from filing processes, and also stopping them from practicing. The seal and stamp policy, alongside the compulsory payment of practicing fees, helps to ensure that it is only legal practitioners that are supposed to practice that actually practice. Now, what if I don't have a seal and stamp? Is my signature strong enough? Unfortunately, your awesome signature isn't strong enough for the courts to give you a waiver, so you need that seal. What about lawyers in full-time salaried employment? Well, these lawyers in salaried employment aren't serving court processes on behalf of their employers, so any letter they write to the potential clients of the employers won't need a seal and stamp. If these lawyers go ahead to file processes for clients that aren't their employers, however, then they have to frank them with a seal and stamp. Now, you'd think that the lack of a seal and stamp would render the document void, but that's not the case. It's just deemed irregular, and such irregularity can be cured by getting the seal from the NBA and affixing it on the document. And if you put your thinking caps on, your follow-up question would probably be, why go through all the stress of making that rule if the consequence is almost non-existent? Now, in my personal opinion, I believe that this is where equity comes into play. Imagine if the court processes become void just because the lawyer forgot to do the needful. That would be gross injustice to the client, don't you think? Now, let's do a quick recap of today's lesson. Firstly, a seal and stamp is compulsory when you want to file your processes. If you don't affix it, it doesn't render your documents void. It's just seen as a curable irregularity. Also, it's not all documents that a lawyer has to put the seal and stamp on. Just on legal documents when he's acting as a legal practitioner. This rule goes hand in hand with Rule 9, meaning that if you haven't paid your practicing fees, then you can't even apply for the seal and stamp in the first place. Rule 11. Mandatory Continuing Professional Development, CPD. Last time we talked about the seal and stamp. Now we're talking about the Continuing Professional Development Program. So what's it about? It's a mandatory program for lawyers to make sure everyone is up to speed on the current trends. It's designed to engage lawyers with various activities so that we have intelligent lawyers in the field. These activities include stuff like attending and participating in accredited courses, attending seminars, attending law conferences and workshops, legal writing in journals, newspapers, books, etc. All these earn you credit hours. Gosh, I wonder if what we do actually earns us credit hours. Speaking of which, what are credit hours though? They are a unit of measurements that represent the amount of time dedicated to learning something. Now, obviously, for credit hours to count, there has to be a body acknowledging these credit hours. In our case, that's the NBA. Let me quickly list out the default credit hours that the RPC gave us. If you're a baby lawyer up to your 5th year post-call, you have 24 hours total to fulfill each year. If you are above 5 years to 10 years post-call, then you have 18 hours. If you are above 10 years post-call, then you have 12 hours. Just see them as a required XP point you have to get in a video game before you go to the next stage. Now, if we pay close attention to Rule 11 Sub 4, these credit hours that I just listed are the default credit hours, which are subject to change by the NBA in its rules or guidelines. Just recently, the new MCPD Rules 2025 have effectively overridden the default credit hours provided by the RPC. So according to these new rules, you need at least 5 credit hours on a calendar year before you can practice, regardless of your year of call. This is supposed to help with easier compliance. If you're interested in my rant about credit hours, feel free to check out this video right here. So now all this talk about credit hours, what if you don't do it? Well, if you decide to ditch the program, you won't be issued your annual practicing certificate, and you would be disqualified from practicing forever. Nah, I'm just kidding. You will only be disqualified for a year, but make sure to do it. Rule 12. Annual Practicing Certificate. Okay, this one's going to be very short, so I'll just go straight to it. Every year, there's a list compiled and published by the NBA that's called the Annual Practicing List. This list contains all the names of people who have done their CPD program successfully and paid their practicing fees. If you don't know what CPD is, check out the previous lesson. If the lawyer doesn't get his annual practicing certificate, then his name won't be published on the list, and that means he'll be disqualified from practicing in the next legal year. If he can't practice, that means he can't take part of or conduct any court proceedings, sign any documents or processes, and can't file same in court. If you've noticed a pattern, rules 11 and 12 go hand in hand, just like rules 9 and 10. If you put all the 4 rules together, I believe they are meant to act like safeguards to make sure that clients get competent lawyers. But that's just me. What do you think about these 4 rules we've talked about so far? Are they actually made to protect the interests of the client? Or are they just ways to make sure that the lawyers pay their practicing fees to generate revenue for the MBA? Let me know your thoughts down in the comment section. It'll be interesting to have some dialogue in the comments. Rule 13. Notification of legal practice. So when you want to commence your legal practice, or if you're already practicing, if you want to change your address, it is ethical to notify your MBA branch about it. You have to give the notification not more than 30 days from the day you commence practice. So what should the notice contain? The notice should contain the following information: the name of the legal practitioner, so basically your name. Another information that is required is your address where the legal practice is carried on. So unless you've decided that your office will be located in your house, please don't put your house address in this one. It's for your place of work. The next thing to put is the date when you were called to the Nigerian bar. And finally, you put the date your name was entered into the role of legal practitioner. When you've given MBA this notice, the MBA branch puts all that information in a register or database, which brings us to our next question. Why do they collect your information in the first place? One reason that comes to mind is that the MBA wants to be able to track you whenever they need you. Maybe a court bailiff that wants to serve processes, or a law student who has been posted to your office for his externship. If you move and you don't give the MBA notification, your old address is what will reflect in the database. Now that's good and all, but what happens if you don't notify the MBA? I don't know. Personally, I don't think there's a consequence for not doing it, and there's no sanction attached to not notifying the MBA. But I believe it's ethical to notify them so that it puts less stress on people trying to find you. I mean, fuel isn't cheap, but I'd like to hear your thoughts on this in the comments. In conclusion, let's go over the important bits one more time. So the most important things to know about this rule are: notify the MBA not later than 30 days after commencement of legal practice if you are just starting out. If you've been practicing for a while and you just want to change your address, notify the MBA not later than 30 days after the change. Then your notice should contain details like your name, your office address where you are practicing, the date you were called to the bar, and finally, the date your name was entered in the role of legal practitioners. If you leave here with all these in your head, then you have zero problems with Rule 13. And that is it for the first compilation video. Stay tuned for the next compilation video where we'll talk about part 2, relation with clients. As always, make sure to like, subscribe and share with your friends. And I will see you next time.